I think the judiciary have a very important role as guardians of the rule of law. I think if our democracy is functioning properly, it ought to be the last resort to go to court to defend the rule of law rather than the first, because I think that public and parliamentary opinion should make resort to the courts unnecessary. But if all else fails, then I conceive the judges as having a hugely crucial role. I quite strongly disagree with Lord Newberger on this subject, as I think I told him. He's a very good friend of mine, enemies or anything like that. But it seems to me that the law of unintended consequences can be relied on as a reason for never doing anything, because you never know what may happen. This creation of the Supreme Court, in my opinion, was an overdue reform, a valuable reform, and I simply do not accept the probability that the judges are going to get a rush of blood to the head and behave like maniacs at some point in the future. After all, the judges are exactly the same people as manned the appellate committee in the House of Lords. Why the fact that they've moved from one building to the other across Parliament Square is going to make them behave differently, I simply do not understand. What Lord Wolfe has at the back of his mind is the fact, well known to us all, that most countries of the world have a big C constitution, which is the Supreme Court, the supreme law of the land, and which is entrenched in the sense that it is superior to everything else and can't be altered except a constitutional amendment. And that is notably, of course, true in the United States, but it's true almost everywhere except New Zealand. But it isn't our law, and we all know perfectly well that it isn't our law. Parliament is sovereign. Why a whole lot of really sort of learned and responsible people should overlook that, I can't imagine. What I think is true is that courts, the behaviour and sort of temper of courts, which depends to some extent on the personalities who happen to be sitting in it, can operate in a sort of cyclical manner, so that you will get a court being forward-looking, progressive, even perhaps slightly adventurous for a period. And then that will be followed by a period of sort of quiescence and consolidation and sort of rather pulling in of horns. And one can see that certainly in the United States Supreme Court, one can see it in the High Court of Australia, and no doubt you can see it in other courts as well. I don't think myself the appellate committee of the House of Lords has been notably reticent in recent years. Indeed, I think it's been quite progressive and forward-looking. So it wouldn't surprise me if there weren't a period now of some consolidation and retrenchment. But that's the natural course of things. Absolutely not. We all know perfectly well that the courts in this country have no power to strike down legislation. There have been various murmurings extrajudicially by some of my colleagues who've thrown doubt on that doctrine. There was an academic article describing these remarks as unhistorical, unargued and unsound. I actually agree with that. It's not language I would have used. Yes, the handling of the whole enterprise was a complete cock-up.
Yeah.
It was a nonsense. There was no consultation. There was no Royal Commission or anything like that. When the Judicature Acts were passed in the 1870s. There'd been a commission that had sat for years, but really sort of chewed the thing over and came up with a scheme for reforming the divisions of the High Court and all that, which essentially is what we still have. Very, very carefully thought out, well debated, etc., etc. This new scheme came out of a hat. History may, I suppose, someday relate quite how it happened. It was clearly linked with the government's wish to get rid of the office of Lord Chancellor.
And Derry.
Probably.
Yes.
I mean, I'm not sympathetic with that. In many ways, he was a very good Lord Chancellor. In almost every way, he was a very good Lord Chancellor. But he was clearly an obstacle in the way of Tony Blair if he wanted to turn the whole system upside down. And Derry, with whom I did discuss the matter, not at length, but briefly, was against a Supreme Court.
Oh, right.
He didn't favour it. I think because he thought, perfectly shrewdly, that everybody would say, well, if the Lords are going to go somewhere else, why doesn't the Lord Chancellor go with them?
Yes.
The practice, very, very recently, has been to advertise. And I think certainly for, as it were, associate members of the court, that is a good idea because it encourages absolutely anybody who thinks they could do the job and would like to put their hat in the ring and offer themselves consideration. I think we shall continue to put a good deal of a premium on experience and practice, so that the notable successes as judges of people who haven't been barristers, Lord Collins and Justice Beatson, both had a lot of experience of the practical, the very practical side of litigation. However, I'm sympathetic with the premise of the question. I don't think we should be too hidebound. I think we should look for the best candidates wherever we find them. But in former roles, I have always been resistant to allowing people to opt into the judiciary halfway up, because, in the first place, the most difficult job in the law is being a judge of first instance.
Yes.
You've got to make decisions there and then, and you can't say, well, I'll think about it and come back next week. You've got a jury sitting there wanting to know what the answer is and so on. And also because it downgrades the significance and weight of the lower offices if clever people think, oh, well, let's skip all that and go straight to the Court of Appeal or something. So I have always been, as Chief Justice, rather against and senior law appointing people on a sort of leapfrog basis. But I couple with that would say that if somebody is sufficiently outstanding and exceptional and has enough to contribute, that shouldn't be an absolute consideration. I wouldn't have any absolute considerations on this matter.
Even if they were, say, an academic and not a barrister by trade, or? Yes,
I mean, Baroness Hale, Sir Justice Beatson, for example, or Justice Maurice Kay in the Board of Appeal was a professor of Lord Bingham at Keele. It's beneficial for people to have some experience of the law in practice as well as in academia, because it's quite the same. But Lady Hale is an example of somebody who's adapted very quickly and very well. I have actually resisted, in my time, almost every change to the process of judicial appointment, because it worked very well as it was. However, I have accepted reluctantly that there was a perceived sense, very widely shared, that the whole system was, as it was, extremely opaque, lacking in transparency. Accusations, which I don't think were justified, but difficult to rebut, that there was too much sort of old boyery about it all. I think the Judicial Appointments Commission was probably a necessary step. And I think on the whole they've done their job well. Whether they've appointed anybody differently from those who would have been appointed anyway, I'm much less sure. Though there was an enormous merit in the old system whereby the Lord Chancellor knew a lot of people and backed his personal hunch. Lord Irving, you mentioned before, was particularly good at this. He'd come straight from the English bar. He knew the judges and said, well, I think so-and-so ought to be promoted because he's just very, very good. That would be good. He's excellent, he's quick, he's very intelligent, he's down to earth. Got all the right qualities. The second part of your question, do I think that we should move to a sort of much more political style? No, I don't. The Act as it stands very much, of course, reduces the political input that could theoretically be exercised by the Lord Chancellor before, and was until about the 1930s, I suppose. I mean, you prefaced your question by saying, do I think it's satisfactory that the Lord Chancellor should have any continuing, or should have the final say?
Yeah.
So, if you've read the Act carefully...
I can't say I have, no.
Go to the back. If you've read the Act carefully, you'll see it's a very, very limited discretion. As it is with I mean, I've chaired 2 panels who recommended, in one case, my successor as the prospective President of the Supreme Court, and in the second place the Lord Chief Justice. And the Lord Chancellor had certain rights to say, I don't like your candidate, think again, or please reconsider this. But he has to give reasons. And he can only reject somebody if he's satisfied that the person is unfit to hold the office. I mean, what competent selection body is going to put up a man or somebody who is unfit to hold the office? Yes. And that is a decision that will be judicially reviewable.
Jack Straw says the creation of the Supreme Court provides greater clarity by further separating the judiciary from the legislature, underlining the independence of the judicial system. Is the Supreme Court likely to achieve the separation of powers?
I mean, you and I sure appreciate very well that in this country we do not observe the separation of powers between the legislature and the executive. The leading ministers are members of one another House of Parliament, so you've got a very close overlap between the two. But we have had for very many years a very clear separation between the judiciary and the executive and the legislature. There were only 2 things which blurred that separation. One was the existence of the office of Lord Chancellor, who was both a legislator and a minister and a judge. And the second was the existence of the Lords of Appeal in Ordinary, who, although paid professional full-time judges, were also free to and encouraged to legislate. And in days past, they regarded this as a very important duty. They attached great significance to it. Lord Reed, highly regarded, very highly regarded judge, said on one occasion that if there was any sort of conflict between his duties as legislator and his duties as judge, he would put his duties as legislator first. Well, that's not a view that has been accepted during the last 10 years of the Appellate Committee. when the legislative contribution of the Lords shrunk to virtually nothing. That, I'm not talking about the people who'd retired, I'm talking about the serving judges. I mean, they simply didn't contribute, with one or two exceptions, and always very happy exceptions. So, yes, I agree with Chancellor, and this does make the separation more complete and more obvious. Well, I don't see much wrong with that, really. I would think there was everything wrong with it if he was a judge as well. Everything wrong with it. I'm not sure. I mean, in previous offices, I was sort of fairly intimately involved in working with the Lord Chancellor of the day. But that ended effectively in the year 2000, which was still the old regime, if you call it that. So I have much less knowledge of how the new machine actually works. It has some quite serious drawbacks. I mean, in terms of judicial appointments, the time it takes to appoint somebody as compared with what you could achieve in the old days is extraordinary. And it has become much, much more bureaucratic. So there's a whole lot of functions that the Lord Chancellor's office used to deal with, like complaints about sort of discipline and this sort of thing. And now dealt with by the judges. It's just an extra workload for them. Well, you will find them, I think, in the next edition of Public Law. There's a lecture which I gave in Leicester in honour of somebody called Jan Budetsky, who's a great figure of that. What I suggested was that the House of Lords as a legislative body should cease to exist. But that it should be replaced by a body, we could call it anything you like, but what I was suggesting was a council for the realm, which would not make law, but which would have a statutory right and to be consulted on proposed legislation and on the detail of legislation as it went through Parliament. The Commons would have a statutory duty to pay attention to its proposals. And its membership would be very, very much the same as the existing membership of the House of Lords. In other words, it would have many, many more people than the House of Commons who have no political axe to grind of any kind, i.e. the crossbench element, which is currently the House of Lords. And it would have, again, like the House of Lords, but unlike the House of Commons, a lot of people with very detailed, specialised knowledge of particular subjects, whether scientists, doctors, diplomats, civil servants, whatever. And so it would bring a very, very expert judgment to bear on legislation going through the House. Now, what I was proposing, it would be quite a big number of people, but they would attend when they were summoned to do so for a particular job of work. When they did attend, they would be paid, and they'd get their reasonable expenses, but you wouldn't get 450 people turning up
every day, for instance,
on any old afternoon. The bedrock of this argument is that unless the members of the House of Lords were appointed, were elected in the present role as lawmakers, they would never be regarded as democratically legitimate. But you could never elect a House of comparable quality with what you've got at the moment, because who's going to hack around constituencies, these top scientists, diplomats, etc. It's just not good. I think for a number of reasons for the growth in judicial review. One of them, very, very important one, is the change that was made in the rules for applying for judicial review. In about 1970s, perhaps late 1970s, they reformed the rules that governed applications for judicial review and greatly simplified it, made it much easier. It then became quite clear that there was a sort of unsatisfied demand to challenge decisions of local authorities and public authorities, ministers, bankers, those kind. And so the number of cases has proliferated. I think it's very important to bear in mind that the judges don't bring the cases.
Yes.
I mean, no judge can ever rule on a case that somebody hasn't brought. No, I don't think they've become political at all. I think they have become readier to say than they certainly than they were 50 years ago, that a decision is irrational or contrary to evidence or whatever. But I don't think there's any political element to that. I mean, they do it to all governments. I think we're actually seeing fewer judges doing it than we used to.
It's funny you should say that, because Lord Phillips said that, but Lord Wolfe said the opposite.
Well, I don't agree with Phillips. The fact is that in Mrs. Thatcher's time, there was an inquiry into the Crown Agents. There was an initial inquiry into a body called the Crown Agents, which was a sort of government procurement agency for the Commonwealth and the colonies, and it all went wrong. And there was a small, not unsatisfactory inquiry, and then a much bigger inquiry was ordered under the chairmanship of the High Court judge, and it lasted for about 3 years or something. It produced a very, very good report, but by the time the report appeared, nobody was the least bit interested in the subject anymore. And since then, there have been really rather few. Mrs. Thatcher just thought it was a waste of time and money. I would have thought rather few judges have done things since then. But the question is, I mean, my view, I've done a couple. One as Queen's Counsel, one as Lord Justice. I think judges need to be quite careful about what they're getting themselves into. But provided the reason for asking a judge to do it is because it is thought that a judge can bring certain judicial qualities to bear that the situation probably needs, I think that makes it more or less legitimate. If what the government are trying to do, this is not infrequently the case, is to simply trade on the reputation of the judges, then that can be dangerous. Lord Devlin years ago said the reputation of the judges is such that government after government is tempted to plunder it.